We have one more very dynamic speaker who's going to round out our day. We're going to be talking about workplace complaints. Many of you are in-house counsel, and you are the first line of defense when it comes to handling workplace complaints. And you all know that a well-run investigation can put your company on the right track from the start, or it might go off track with investigation and lead down the line to more litigation. Under the backdrop of recent NFL investigations, including the Ray Rice investigation and Deflategate, trial lawyer John Romeo from Gibbons in Philadelphia will discuss best practices for avoiding common mistakes in investigations that can often make matters worse. Please welcome John Romeo.
Thank you. It's actually great to be back here. I'm back here for the first time as a member of the Gibbons firm. I've been to several of these events in the past as a guest. I was in-house counsel with a national utility for about 10 years. And in that role, I was also the chief compliance officer and oversaw every investigation that the company did across the country. So I gained a lot of experience there, and I've carried that forward to what we're doing here at Gibbons. And so I wanted to spend a little bit of time talking about that. Got to make sure I know how to use the technology. So where I want to start is, I did an investigation once that was very involved, resulting in the termination of dozens of people in a class action arbitration filed by a union. And after 2 weeks of a hearing, the arbitrator issued this decision that included the following. The board believes that the hearing record shows that the company conducted a fair and thorough investigation, that the investigator conducted himself in a professional and objective manner. And I include that because that's what we're looking for. We want a fair, thorough, professional, and objective investigation. And if you do that, that investigation gets upheld down the road. And it can provide a lot of defenses against potential liability from claims from the complainants, claims from the targets, and everybody else. Now, you would think the NFL, being a multi-billion-dollar international corporation with a commissioner who makes $30+ million a year and investigators that get paid in the millions of dollars to conduct investigations, would get it right every time. But anybody that's been following the news knows that's not true. Some recent headlines: the NFL ignores ball deflation science. NFL owes the court a correction. The NFL lies. Others include statements like the NFL's investigation is a three-ring circus, or they follow their own faulty and warped rules of investigation. That's not what we're looking for when we conduct an investigation. That doesn't usually result in positive consequences, and certainly doesn't help defend against liability. So we're going to talk about three particular issues today. The Ray Rice case. Ray Rice committed domestic assault against his then fiancée in an elevator at a hotel called the Revel in Atlantic City, New Jersey. The next one is Richie Incognito, a little bit less covered, but Richie Incognito is a lineman for the Miami Dolphins who harassed and bullied another lineman in the locker room based on race, sexual orientation, and other things. He was ultimately suspended by the league. And then Tom Brady and the Patriots with Deflategate, which I'm sure most of you have heard of, but it has to do with balls being inflated at 11 pounds per square inch instead of 12. Full disclosure, I'm a Patriots fan. I'm from Boston. So that investigation was a fraud and a sham from the beginning. I want to make sure everybody knows that. I'm done. Thank you. So look, we're not going to be able to cover today every aspect of an internal investigation. We don't have the time for it, and I'm not going to try to do that. What I'd like to do is talk about some common mistakes in the context of some of these NFL investigations and the results that those mistakes had. Primarily, we're going to talk about the preparation of the investigation, whether you have policies and practices in place, and whether you've trained your investigators, and there's guidelines for those investigators. Responding to allegations, the investigation itself, and then taking corrective action. We're going to look at that in light of some of the mistakes that the NFL made. So first, we'll talk about responding to allegations. Allegations come in many forms. It's easy when someone walks into the chief compliance officer's office with a written complaint and says, "Can you investigate this?" It's less easy when someone says to a friend over a beer after work that they have an issue and they don't want anybody to get in trouble and they don't want it investigated, they just want to let you know. It's less easy when there's some horseplay that a supervisor or manager sees but isn't really sure what the issue is or what should he do about it or what should she do about it. But we're putting managers in a real bad position there. The rule is quite simple. If your managers are aware, or supervisors are aware of the inappropriate conduct, they have a duty and an obligation to do something about it. What they need to do about it is follow your protocol. We want to make sure we're not putting them in a position to make too many decisions. We're not asking them to go out and conduct their own little mini investigation and have a consequence right there on the spot. We don't want them to determine the motive. Oh, that person's only complaining because they got a bad review. If someone was sexually harassed, kept quiet about it for a year, got a bad review and said, I'm sick of it, I'm going to complain, their motive for bringing the complaint forward is irrelevant. We don't want to put that on a manager's, we don't want to put that burden on a manager to determine whether or not they need to make that decision to investigate. Have a protocol, get into the proper hands so that the trained investigators can take action. Richie Incognito, for months, harassed and bullied Jonathan Martin for the Dolphins. 2 of his coaches were aware of it. At times, arguably, although they denied, participated in it, but did nothing in the face of an NFL policy that said everyone is to report any incident that may be a violation of the policy. Why didn't they? They didn't know if it reached the point of being a violation of the policy. If you know any of the facts of the case, which I don't dare repeat here, it's obvious that they're a violation of the policy. But more so, their concern was that there was no formal complaint. Jonathan Martin didn't come forward and complain. He just sat there and took it. And therefore, why should there be an investigation? Well, that's not right. And I'm telling you, there are multi-million-dollar verdicts, time and time again, because a manager or a supervisor was aware of a situation and didn't take proper remedial action, didn't start an investigation. And then you no longer can defend yourself by saying, we had these processes in place, we investigated, we took action, and you've now defended yourself against potential liability in certain cases. So next, we want to move to conducting the investigation. First question is, do you investigate or don't you investigate? I'm a big believer that you must document everything. You document your process and you document the facts. If you determine not to do an investigation, you document why. So if it ever comes up, you can show that you thought about it, it was a deliberative decision, and you decided not to, okay? If you're going to conduct the investigation, do it promptly, do it effectively. Don't set unrealistic goals, and don't make unrealistic promises to someone that we'll have an answer for you next week and it looks like this person did something wrong. You're doing the investigation. The biggest mistake I see in investigators that are untrained is that they have a theory up front, and then the purpose of their investigation is to prove it. They spend their entire investigation proving. I would tell you that's what happened in Deflategate. They had a theory that Tom Brady was doing something, and they spent tens of millions of dollars to prove it. And the reality is that's the worst thing you can do. Your job is to go get the facts. Once you get the facts, draw your conclusions based on those facts. So the NFL, I mean, right after the football game where Deflategate started, they came out with a statement that said they would have an answer in 2 to 3 days. 3 days later, they said it's going to take longer than that. 3 months later, they started getting critiqued by everybody for what are they doing? Are they ever going to address this? This was their own self-created problem. They made an unrealistic promise. We'll get this done in 2 to 3 days. This didn't have to happen. They could have said there's a lot to look at. It's going to take time. We're going to need experts. And then people would not have critiqued them. So don't create situations where you put yourself in behind the 8 ball because you've said you'll do things that you just can't do. At the beginning of every investigation, you want to understand your goals. You want to understand your strategy. And you want to have certain questions that you need to answer up front. What is the scope and what are your objectives of the investigation? Some people take a very defined approach, okay? This is our scope, Richie Incognito. We are going to look in to see whether or not he bullied or harassed Jonathan Martin. During that investigation, it came out that Richie Incognito was using steroids and other drugs. And in the investigation report, actually this was shocking to me, they said, that's not within the scope of our investigation, we're not going to look into that. That was a little shocking to me. My opinion would be I would be more fluid than that. And if I saw other issues come up during the investigation, I would probably explore those. If you're the investigator, you might want to go back to the decision makers and recommend that and let them make that decision. But I still think that's the normal course. Be more fluid than locked in on your scope like that. Interim measures, do we need to separate Incognito and Jonathan Martin, or can they stay together? You want to consider whether there are safety issues or other issues that mean we can't just live in the status quo while we figure this out. Other things, whether you need a litigation hold, if it's a union environment, there are other things that are impacted about whether or not they have what are called Weingarten rights, meaning they get a union rep there with them. I think this is one of the most important things you do. You have to select your investigator. Yes, they have to be qualified. Yes, they have to know how to conduct an investigation. But importantly, they have to be impartial. They have to be unbiased. And if they're not, then the entire investigation is going to lose credibility. It's going to be questioned, and then you're going to have a hard time defending it. I look at every investigation and every aspect of every investigation that someday I'm going to have to defend it. So when that 2-week trial in that case, the first quote we had here on the first day, I was on the stand myself for 3 days, going through every aspect of my investigation, every witness interview, everything that happened. If you are in a position where you don't have documents or you don't have notes or you can't defend a decision you made, it's hard to uphold your investigation and the results if you don't do that. So it's very important that you have an impartial investigator, or else everything that investigator does seems biased. It's hard to be fair and objective if you appear to be biased. And it's not just whether or not you will be impartial, it's whether you're going to be viewed by others as being impartial. So right off the bat in Deflategate, the NFL appoints a former Jets executive to oversee the investigation. The Jets and the Patriots are division rivals. They hate each other. The Patriots don't trust them. They think that this is all part of their bias. Okay, not a big deal, but it goes farther than that. It goes to Ted Wells. Ted Wells of a law firm gets paid millions of dollars to conduct an independent investigation.
I would like to start out by responding to criticisms by Mr. Brady's agent, Don Yee, about my independence and his suggestions that the conclusions of the report were somehow influenced by persons in the league office who wanted to find wrongdoing by the Patriots and Mr. Brady. The conclusions in the report represent the independent opinions of me personally and my team, and those conclusions were not influenced in any way, shape, or form by anyone at the league office. We made a fair and reasonable review of the evidence, and we reached conclusions based on the preponderance of the evidence standard, which I was required to apply based on the league's rules.
7 different times in his order, he put the word independent in quotes. I think he was making a statement that he didn't believe him to be independent. And he coupled that at the end by saying, by the way, you can't be the independent investigator and then counsel representing the NFL at the arbitration. It just doesn't make sense. So it's just something to keep in mind. If you have your everyday counsel who's going to be representing you down the road, you don't want to lose that ability and you want to maintain independence, you might want to hire somebody else for the investigation that isn't also going to be your counsel. The New York Times, Ted Wells goes out and hires an expert to talk about the ideal gas law. Why does the pounds per square inch in a football go down in the cold weather? And their opinion was debunked by several experts. And the New York Times reported that Exponent was a hired gun for the NFL. You have a hired gun, you have independent investigators. When you do this, you've lost faith in the public, in a case like the NFL, the public. In most of our situations, our employees will lose faith in us, they'll lose faith in our process, they'll question our integrity and our approach. That's not the morale boosting situation we want to have when we're doing an investigation. Next, we want to make sure we review all the relevant documents. Social media, emails, phone messages, phone logs, anything that might be relevant, review it. If you don't review it, document why you didn't review it. Real quick story, doing an investigation, a guy was missing repeated Sundays during the football season. And he would call out sick on Sunday almost every day, almost every Sunday during the football season. So his manager complains, and they start an investigation. I didn't do this investigation, somebody else did. And it gets reported back to me that they have his Facebook page, and there's a post of him, a selfie, at the Steelers stadium taking a picture of himself. Well, the Steelers are losing. I think the scoreboard was in the background. They're losing like 33-6, and it says, "I can't believe I took a sick day for this crap." So perfectly appropriate to review that social media page and make a decision based on it. But if it was a private page, we never want to use some form of deceit, creating fake pages to get in and see things. And in most states, or many states, you cannot ask an employee for their password or login data for their private information. NFL, Ray Rice. If you've seen the video, you know what I'm talking about. Gets in an elevator, punches his fiancée in the face, knocks her out cold. There's an investigation. All the NFL had was a video of him outside of the elevator, not inside the elevator, and they suspend him for a couple games. There was a review of that investigation, and the Robert Mueller report, who reviewed their investigation, said the NFL didn't do enough to gather documents. They could have gotten that video. Ray Rice had it, the hotel had it, the police had it. They didn't ask, the Ravens had it, but the NFL didn't have it, and the conclusion was they just didn't do enough to get it. If you're going to do an investigation, do it right. And then there was facts that came out that said they actually had it. They just ignored it or didn't include it. And Senator Blumenthal, the Democrat from Connecticut, thought that that alone was enough to make Roger Goodell lose his job for having that video and not using it.
Well, the National Organization for Women is reporting that during Roger Goodell's tenure as commissioner, there have been 56 instances of domestic violence. But in response, the NFL has suspended players for only 13 games combined.
Clearly, the NFL has failed before. If Roger Goodell lied to the American people about something as serious as whether he had this graphic, gripping tape, he has to go for the sake of the NFL and the fans.
Now, that's a guy that makes $30 million a year, sets up these investigations, and that's a senator of the United States saying, if you didn't look at the right documentation and you had the ability to, you need to lose your job. Now, that's public, but think how your employees would feel, your clients, if you were doing similar things, maybe on a smaller scale, but think about the impact of not reviewing the relevant evidence. I'm a big believer, I said it earlier, in documenting everything. Not just the facts that you get from the interviews, but the process. If you don't talk to a witness, document why you didn't talk to that witness. Make sure that your notes from any interview are consistent with your ultimate report. Inconsistencies will call into question the investigation. And make sure that the conclusions that you draw are based on the actual evidence in your notes. And that can be a big problem if you don't do that right. So, for example, in Ray Rice, the case went to arbitration about whether Ray Rice he ultimately was then suspended permanently. And he sued and said, hey, I was already suspended for a game. I can't now be suspended permanently. The question came now to, did he tell the truth during the first investigation? And the top line is a quote from the actual arbitrator's decision. The commissioner's notes are not detailed and do not contain any verbatim quotes, as opposed to the NFL Players Association's lawyer's notes, which were detailed, they had quotes, and they very clearly said, in quotes, and then I hit her. And while that doesn't make Ray Rice a nice guy by any stretch of the imagination, the reality is he had told him the truth, and the arbitrator said, look, the testimony was close. I don't know how I would have decided this, but with these notes, it's a no-brainer. And I have to find in favor of Ray Rice, and the arbitrator, she reversed that arbitration award. Likewise, what you see there is two gauges that are used to measure balls in the Deflategate case. There were two, and they were about 1/2 pound per square inch off. The referee said that he used the small one, the non-logo gauge, or he said he used the logo gauge, which created a higher initial measurement. Despite the fact that the only testimony in the whole case was that he used that gauge, the conclusion was that he used the other gauge, and then Exponent did their whole report based on the other gauge, which made it look like balls had been deflated more because they went down 1/2 pound per square inch, which was outside the realm of what physics would tell us would happen, whereas if it was the other gauge, the gauge that the ref said he used, that would have been within the ideal gas law, and the Patriots wouldn't have been shown to have violated any rules. So if you have evidence that says we did X, and your conclusion is they did Y, you better be able to explain that, and if you can't, your whole investigation will be called into question. I realize at this point that I'm standing between everybody and their afternoon activities, so I'm going to wrap up in a couple seconds. Confidentiality is important for a myriad of reasons, but safeguarding the confidentiality of the investigation to the extent that you can. You know, obviously, if somebody needs to see the information when you're done with your report, that's going to happen. Never guarantee it, but do what you can. I just want to say quickly, the NLRB takes the position that you can't require employees to keep their investigation confidential. I have my own personal opinion of that decision. There are exceptions to that if you can show that you wanted confidentiality for witness protection or to avoid a cover-up or fabrication of evidence. I would submit in most investigations, one of those will fit the bill. Most of those reflect on the integrity of the investigation, and just document that you're asking for confidentiality for that reason. The NFL, on the other hand, leaks everything. And then most of their leaks turn out to be wrong. And then when they're wrong, they then have to try to prove them right, or else they were leaking information that was wrong. They created these unrealistic expectations. They were their own worst enemy in these investigations with the information that they leaked. And then lastly, taking corrective action. It's simple. It should be prompt, consistent, and remedial, designed to stop the behavior. It seems simple. You would think you would get it right. You heard in that video, the announcer said 56 cases of domestic abuse and 13 cases where they took action. How is that consistent or proper? So you need to do it right. Here's what happens when you do it wrong. Ray Rice gets a 2-game suspension, public outrage. He gets brought back in. He gets permanently suspended. He goes to arbitration. He gets reversed because he already had a 2-game suspension. Everybody looks bad. The reality of the situation there is if they had done it right in the first place, they wouldn't have that problem. And while this is public outrage, like I said earlier, no different than if you did it wrong, your employees would be outraged, and you'd lose the respect of your employees. So just to wrap up, some common mistakes that happen. I talked about them all. Avoid the sham. Don't do an investigation to prove a predestined result. Make sure your investigator is impartial. Conduct the investigation promptly. Document everything. Make sure your conclusions are based on the evidence. Maintain confidentiality to the extent possible, and take prompt, proper corrective action. And that's all. Hopefully the NFL can start getting it right going forward, and go Patriots. Enjoy the rest of your afternoon, everybody.